Can we say Happy New Year? I know it's not.
We're getting close.
Not quite there, but this is our last episode for the season and
closing out
year.
a good 2023.
Yeah,
it's a good
I know. Episode 99.
Yeah, that's wild, eh?
Looking forward to it. I know it's kind of cool. Episode 100 is going to be in the first episode of the year.
I think Max, our producer, is going to be coming in a suit for episode 100.
Mm-hmm. There's going to be
cake. We're going to come in tuxedos.
Yeah, there's going to be cake.
I'd say, can you believe we've been doing this long? Except for you've been doing this for like 30. Do you want to say how many years?
I'm in my 31st year, and you're in your 31st
I
or
stopped
32nd.
Counting. Who's counting?
You're older than me, but you have more hair.
Yeah,
and
I know.
And it's still blondish.
Blondish, yeah.
Do you diet?
No.
You diet. Tell me.
You never asked that.
Did you say die or diet? I don't diet for sure. I should diet.
Oh my gosh, you guys are funny. So, but I think one of the things that we found doing this podcast is that everybody has been really receptive, and they're so excited to see sort of the inner workings of the system. And there's a barrister. Well, sometimes works. That's what we're going to get into. But there is a barrister in the UK who I bought the book when it first came out. You can kind of see it's a little bit dated and yellowed, but it's only from 2019. An individual you can find online called the Secret Barrister. And the reason the barrister is secret is because it's dangerous sometimes to talk about what's broken. The book is called Stories of the Law and How It's Broken. That was the very first book.
Yeah.
And I've encountered so many times people taking umbrage. It's the third time I used it today.
Yeah.
That was my word from last week.
Taking umbrage with me calling it the justice system. They say it's not the justice system, it's the legal system. So why would people feel that way?
I think I want to first say this, and I'll say two things. One, we have, viewers from many other jurisdictions, and they love the fact that we talk about our jurisdiction and they compare it to their jurisdiction. Some from Australia, from the UK, and from New Zealand. And it's great to think about the comparisons in the Commonwealth, as well as people from the United States, which is, again, similar but different in many ways. So that's what's wonderful about...
I find Australia is very similar to Canada.
It is.
Yes.
And we them and the UK, we look at their Supreme Court decisions, or used to a long time ago. But so I think that's really wonderful from what happens in our podcast, and that we get this engagement with people from all over the world, very interested in our system versus their system, what's better, what's worse, how can things get better. That's fantastic. I have said this a number of times, that although we will talk about very significant problems in our system, it's a good system. And
we worked hard to get there.
This is taken...
It'll never be perfect either.
It will never be perfect. No. And it's taken, a very long time to get to where we are. But we truly do have, I think, a judiciary and crown attorneys and defense bar that we can all be very proud of, who all want to row in the right direction. And we fight out cases and we disagree on stuff. But generally, I think we are very fortunate in this country to have the system that we have. And I would call it a justice system. It's a legal system, but I think we do get justice. But there are a lot of bad things, and we talk about them.
Well, we know for a fact through things like the Innocence Project that there's wrongful convictions as well. So for those people, they don't feel it's justice, obviously.
Right. They won't. But again, we're looking at it at a more macro level. So when it's very personal to you, and we represent people who come to us specifically because they believe they're wrongfully accused. And we do get those cases where we're able to dig down and look and find the evidence of people who are wrongfully accused. That is sort of our jam, right? So we understand the personal nature of somebody who might be very much aggrieved. And we've spoken about in a previous podcast and other podcasts about how there is really somewhat of a presumption of guilt and other issues. But compared to other systems, frankly, you can get crushed in the United States.
Oh, God, with the
good
sentences.
Luck there.
Yeah, good luck.
And many other jurisdictions. I'd much rather have this system than the civil system in Europe.
Well, there's pros and
or
cons,
Quebec.
I think, from each thing.
Yeah, well, I've done a couple of cases in Quebec.
Oh, okay.
It's not so bad. It's kind of fun.
But I think, like, when we say justice system, like, I do actually mentally picture the scales of justice with the Lady Liberty, for whatever reason it's female. I actually don't want to presume the gender
It's a they.
statue anymore.
It's a they.
But there's the scales, right?
The statues are they.
Okay, I got you.
That's good.
But so the idea is that you get a chance to have the scales weighed properly,
like that.
right?
Yeah.
And it's not like
That's a good one.
It's not like the justice system is staffed by psychics who can actually make sure that they can be sure of what happened. They can just do the best they can with the evidence that's permissible in court.
Right.
And the permissibility reasons, the laws of evidence, they're so complicated. Unfortunately, people need to have lawyers to navigate it properly most of the time.
Yeah.
So that's kind of my summary of how we get from justice. I think justice system is fair enough.
I do. So let's talk about the Secret Barrister for a second, then compare it to us. What were like two highlights from the complaint of the Secret Barrister?
Well, there's a lot of stuff that was unique to the UK at the beginning of the book. That they have a thing called the magistrate courts, which we don't have here, and there was some concern with the appointment of the trier of fact, who was not necessarily qualified properly. There was also issues of the prosecutors being overworked. So prosecutors would show up for a case and not even know anything about it. And there's similar things in terms of the defense. There was an interesting...
And they're absolutely abysmal legal aid system.
Yeah.
Barristers are
So the legal aid...
chronically underpaid, such that there has been a flow out of criminal defense work.
And further to this book being written, there was actually a big strike by barristers in the UK because the underfunding of legal aid. So they're trying to do this crazy work. They also, as we know from a few high-profile cases that were published in the media, that there's some major disclosure problems from the Crown. And one of the problems for the defense is, you get disclosure from the prosecutor. You don't know if you didn't get disclosure, right? So it's not you can say like, oh, you forgot to give me that other thing that you have that I don't know about, right? And so there were some high-profile cases where evidence came out because, like we've said, not all prosecutors are evil. A prosecutor took over the case and just went, I just don't feel comfortable without disclosing this stuff. And then, exculpatory evidence was, came out and charges were dismissed. And there ended up being 3 cases in a row like that. So they have things going on. He didn't particularly talk about those cases because they came out around the same time as the publication. We talked about that. And then there was a follow-up book called Fake Law, which is really interesting.
Yeah.
And that one I think is really important to talk about too, because that was talking about how the public goes into an outrage sometimes about a case they hear about in the news, but they don't understand what actually happened.
Yeah.
And the case doesn't actually match up. And I'm just saying, I had something about how they described it. I thought I copied it in here. But it addresses how criminal cases are being misrepresented. Oh yeah, the opening blurb of the book says, it asks, could the courts really order the death of your innocent baby? Was there an illegal immigrant who couldn't be deported because he had a pet cat? Are unelected judges truly enemies of the people?
Sounds like a National Enquirer.
So this is what's fantastic, because these cases are actually based on. He's got a third book that just came out. I haven't read yet, unfortunately. I'll get the audiobook. But you can see like the humor that's brought to it. And it is funny the way he's worded it, but at the same time, these are real cases, and the public actually believed those things, right? So how does that happen?
Well, that happens because we have media who doesn't accurately or fairly report. They want the sound bites. They want something that will grab the attention of the viewers or the readers without reflecting what really is the situation, and that's a real danger. I mean, that's what you have with press releases. Press releases go out, they assume somebody's guilty, that they're a horrific human being, it gets withdrawn
right
a year later, and
press
there's no
release
press
is still
release
there.
again.
Yeah,
I think it's symptomatic now of an age we live in where everything is about a soundbite, everything's about an opinion, things are misconstrued on social media on purpose. We don't know what reality is anymore. I mean, I think this is symptomatic of what we're in. But when we talk about our system, I think we could first talk about bail. So
well, and we had a situation. We had a situation where a judge spoke out about unfairness. Yeah, I know you have to keep correcting me.
Yeah,
Justice of the Peace.
We're taking
spoke out about
that.
You got to use it 3 times to make it a day.
Okay, I got to use it 2 more times. Okay.
That a JP spoke out and published an article about So
I just did it twice, so it's good, right? Sorry. Well, she dared me.
So it's our last show for 2023.
She dared me to use it 3 times.
All right, go ahead. Bail. Yeah. So the Justice of Peace came out and
wrote an article about unfairness in the bail courts and did a lot of hearings in the bail courts, and these opinions were shared by their JPs,
their colleagues.
Yeah, colleagues. But this judge ended up getting actually thrown off the bench for a bit, and then thankfully won the appeal, and
was suspended.
Was still disciplined for a short period of time for having
criticizing
done so.
its own. Yeah.
But you don't get undisciplined. That's the problem.
But there was commentary about the importance of judicial independence and judges being able to speak, or justice of the peace, whichever one they be at the time, because it applies to all of them, that they need to be able to speak about things in some fashion, but they are very restricted.
I think it's very important that justice of the peace and judges have to stay out of the fray, because once they start talking about opinions, who knows what those opinions will be, and that can undermine confidence in the justice system. I think it's for people outside of the judiciary who can make commentary, like our podcast, like Crown attorneys if they want to, other defense lawyers who speak out, and there's many defense lawyers who speak out. There's many who talk about the system. I think it's up to us to try and bring this dialogue and discourse out, because I think it could get dangerous for our system if the judiciary started commenting too much.
Yeah, but at the same time, if stuff is broken, it's okay for them to.
Well, here's something people don't. Here's something that people don't really know. So judges don't just sit in court, being judges. Yeah. They have administrative roles, and then they're involved in projects, and they work with defense lawyers, they work with Crown attorneys, they work with other stakeholders in the justice system to try and streamline and make things better.
Right.
So they're actively involved behind the scenes in these in these groups to try and fix some shit. And that's really laudable. That's very good. And they have initiatives. And you'll have initiatives on specialty courts. How do we better deal with drug addiction? How do we better deal with homelessness? How do we better deal with mental health? How do we better deal with bail? So that's a great thing that we have in Canada.
And also, I think, to judges' credit, like, people sort of think, I remember seeing this in some reports, the judge was late for court. It's like, quite often they're doing other things before they come to court.
They're gosh, yeah.
They're on JPTs or conference calls, and they're doing other things. So just like when a jury is there, they can get frustrated because they're sent out of the courtroom for sometimes hours, and they just think, what are we doing? We're sitting around here. They want their job to be relevant and important. And I always get concerned with juries when they're out of the court too often, because they're going to get, I'm worried, angry at the whole trial and then make a decision because they're frustrated.
Look, I mean, judges do a good job on a jury case when they're out, say, we are doing real work.
Yeah.
And it's for a real reason. And, we don't tell you what it is, but trust us, this was
stuff's
important.
happening, yeah.
And judges have to write decisions, which is something they do when they're not in court. Right?
Look, it's not an easy job. And, in Toronto, we've had lots of experience with lots of very good judges. Justice McMahon, for example, who soon is going to retire, which is going to be an end of an era. He's an excellent judge. And he works tirelessly at 7 a.m. or earlier, doing stuff. We'll offer pre-trials at 8 a.m. or at 6 p.m. I mean, judges work hard because the system is overburdened because the resources are not going into it. But let's go back to bail for a second. What is bail, Michael?
Bail's upsetting. That's what it is for me.
Well, what is bail? Explain bail to people.
Bail is, police officers when
You're so opinionated.
I know, I can imagine that. When you're charged with an offense, you can sometimes be released from the police station on an undertaking, but on occasion the police will hold you for a bail hearing. That means you are spending the night in a cold cell, maybe a cheese sandwich, sometimes McDonald's if you're lucky, if it's a nice officer. And then you're being held for a bail hearing the following day in court, where a justice of the peace will decide whether you should be released or not.
Yeah, so on more serious offenses, people will be held for this hearing. On that hearing...
And if you have a prior record, probably.
You often hear that the Crown has to establish why the person should be detained. Or you have to show cause why you should be released. So if you have a prior record, if it's a reverse onus, which means that because of something in your past that's a criminal conviction, it may put you in a position where you have to establish why you should be released.
Bottom line, it's a hearing to decide.
It's a hearing to decide whether an accused person should be released.
Right.
Is there something wrong with my hair? Are we getting like a hair fix here, Marcy?
Well, you jinxed us earlier. And when
It's right here, Matt.
Yeah.
is there a spot?
Yeah, there's a spot. It's called a bald spot.
Have you got that spray from that late night TV? You can just...
Yeah, thanks.
Or given the time of year, we can use that
We had a
fake
happy
snow.
moment when we were up in Oshawa. There we had the two cue balls who were much younger than him, and they had zero hair on their head whatsoever.
All right, so back to the bail. So, you have to have this bail hearing. And
Sometimes you get released on consent of the Crown.
sometimes you get released on consent. It gets determined what it is. Right. Sometimes you can get out on your own signature, called your own recognizance, or sometimes you need somebody to act as a surety.
Someone
so
who's
you can
bailing you out, yeah.
But what are the problems?
Problems is, in the olden days when we started, if a bail hearing was required, the client would go to the police station, 7 a.m., surrender themselves, get processed. We'd be waiting at Old City Hall at 10 a.m. for the bail hearing, and he'd appear, lo and behold. Now, he sits at the police station. The bail hearing is going to take place by Zoom. So you're waiting in your little Zoom box for him to arrive, and that typically will be late afternoon if you're lucky. And even once he does arrive, there's maybe 10 or 20 bail hearings ahead of him that haven't been reached because of the backlog. So you could be sitting, you could be, like we used to tell clients, go in on a Friday or at 7 a.m., you'll be out. I've had clients sit all weekend because they didn't get reached.
I just want to tell a story of this young man. He is so delightful and so traumatized about his experience being held being held overnight.
I'm sorry.
He happened
end of the year.
When he got arrested. He happened to have been in a suit. So he described to me what it was like sitting in jail all night. That he was told they were gonna try and get him a hearing, and then he couldn't get one. And he sat in the cell, and he displayed this for me. And just like you can just. He's just so innocent, sitting there like this, with totally straight in a suit, and he could hear other prisoners, banging and yelling and all this other stuff. And he knew there was a camera on him, so he thought, "I'm just gonna sit here, and they'll realize I'm not like that. They're gonna realize I don't belong here." Mm-hmm. And then at one point, the guard came and said, "They're not gonna get to you tonight," and they gave him a blanket and said, "You should try and get some sleep." So he ended up lying down and had the blanket, and then when he woke up, he put everything exactly, put it exactly back, and it went back sitting exactly like this all the time for the entire night, just thinking, they're going to look at me and they're going to see I don't belong here.
And that did make a difference.
No, he did get released on bail, but
it didn't make it any quicker.
There's no reason. He was a young man who had no criminal record, and there was no reason for him to be held overnight, really.
But that happens a lot.
Yeah, I mean, police are better now at trying to work with releases from the police station.
And COVID created that too.
And COVID created a real necessity for that. And I've seen other cases where they'll meet an accused at the police car and process them and let them go. So there's been improvements, but the problem is the system is under a crush. Mm-hmm. And they've decided to centralize bail hearings to some extent in Toronto, and you got to do it by Zoom. It's not a perfect system. There's a crush of people coming through the system, many who could be released and weren't released. And so you may not get your bail hearing on the first time up. You may not get it on the second time up.
That's horrible.
And you're sitting and waiting. And then the other thing is, you don't have access to a phone.
I've heard this disturbing phrase, it's just like a timeout. Being in jail is not like a timeout.
It ain't no timeout. No. You're not getting cookies
it's not.
and milk.
But you think you have to scramble around to find somebody who could be a surety for you. Right. You get one call, you call a lawyer. After that, the next morning you get to speak with duty counsel and maybe give information as to who possibly could act for you. Mm-hmm. Sometimes I've seen people have to sit there a week and a half to get in contact with friends or family to try and help them. That is really a major problem.
And people who are releasable, that's the scary part.
Yeah. No, so part of our bail system is broken.
Yeah.
Just to be fair, on the genderless balance scales here, there are some legitimate cases where somebody has been released on bail and then committed horrific crimes, and those are the cases where the public ends up, saying, "Let's take away bail."
Well, we're living in an era now where we're going to see bail reform. We're 100%. We already have got bail reform where they
with
slipped
the GPS
in
stuff.
With the GPS stuff, you have to have an ankle monitor. They slipped in, if you have a prior conditional discharge for domestic, it's a reverse onus. Mm-hmm. They've slipped stuff in, but they when unfortunately there's a shooting or a police officer is shot by somebody with a gun, we always see this in the media. We have a revolving door in our
But
in our
out of
justice system.
out of all the cases that exist in the legal system, these are actually just tiny fraction.
Of course.
It is, because if you think about
But
Toronto,
it's overblown because that's the only thing. The only thing you read in the news is bad news.
stuff. Yeah, well,
we have
They should actually just call it bad news.
we have an increase, definitely with respect to carjackings. There are shootings and gang-related activity. I think as we come close to the end of the year, whether it's a macabre stat or not, I think our homicide rate is going to remain low, comparatively speaking, and that's a good thing. But people have the perception that everything is out of control, and it's not quite out of control. Although, I understand people's perceptions. But there are certain areas where things have gotten worse. But that's one percentage. There's another 70% or 80% of cases where there's a lot of people being processed through the system for lots of reasons, many of whom are innocent, and bail is not something that's that easy to get. And then even when you're released, you get released on conditions, and you may be so desperate to get out,
you'll agree to anything.
You'll agree to any condition. Like, I can't leave the province of Ontario. I can't go within 1,000 meters of X, Y, and Z. It can make it very difficult.
Bail is important to talk about because it's been such a big focus, but there's a lot of other things too. I mean, like we've had cases in Canada where there was politicians making comment on a decision in a jury trial that then resulted in legislative changes that made trials more difficult, and these again
more difficult. We've reviewed this before, but since this is an end of year review. Right. That was Mr. Trudeau's amendment with the Minister of Justice at the time, who got rid of peremptory challenges when selecting a jury because there was maybe a verdict that people didn't like by a jury in Saskatchewan, and I get that, but you don't take away a system for picking jurors that we've had in place for several hundred years. I know. And just throw it away.
And then again, just to tie back to what the Secret Barrister is doing is so important. Like you do these interviews with CP24 all the time, and to try and help people understand what's taking place in trials that are going on and are in the media. And that is so important because the reason the public was outraged, they weren't actually at the trial. They didn't hear the evidence. They didn't know how this verdict was reached.
Yeah, I try really hard to bring some sanity to the situation because you just don't get that. And sometimes questions are framed in a way with other people that just doesn't lead to what the truth is. Yeah. But so bail is something where we need to work on. And, there may need to be some reform with respect to how certain high-risk cases are dealt with, but we have specialty units like guns and gangs and others who can be implemented for that. But we need to look at our bail system, and that's one aspect that's kind of broken. The next I would talk about is trying to get your trial on, right? So we have the Jordan decision, which mandates these periods of 18 months and 30 months if your trial's in the Ontario court or it's in the Superior Court, so 18 and 30. But try and get a jury trial in Toronto.
So the Jordan decision, just to clarify, the Jordan decision was made because you have a right to a trial in a reasonable time frame. Yeah. And so then there's how do we decide what a reasonable time frame is? And just because a certain number of months pass doesn't mean that you can actually have your charges dismissed, because if the defense creates the delay, it's not like you have 18 months and you can just say oh, sorry, not available. That's right.
No, you have to be diligent. Yeah, you have to be duly diligent in moving your matter along in order to set it down. Yeah. But there are a lot of real factors. I mean,
I'm just saying that because there was some concern that major cases were being
automatically
because of limits.
It's not. It's much more complicated than that. And there is an analysis. I do think the Jordan decision has played more mischief than it's worth. I think when we had it under Askoff and Morin and others, I think that was a much better analysis than what we have now, because some cases there still is a complexity component to the analysis, but it seems to be not really significant.
And the pandemic caused a lot of chaos.
Well, there's a lot of tweaking that's happened.
Well, and it's the reality is there's a lot to do in a case. There's a lot to do to defend people. If a lawyer's sitting around and has got 4 files, he or she has 4 files. Yeah, they got time to do the case, 4 months from now or 6 months from now.
It just made my heart flutter, the imagination, and we only had 4 files. I was just like, oh my God, I'd be so happy.
Yeah, but look, it's a business. We make a living off of this, and we're good lawyers, so we're busy. Yes. And we want to give each client the time that's necessary to prep the file. And it takes a lot of time. A lot of time to prep the client, a lot of time to work on the defense narrative, a lot of time to draft out a cross-examination. So not everything can be done in these time limits. Right. So, but leaving that aside, you just tried to have a jury trial. I just tried to have a jury trial, and it was adjourned because there's no judges available.
Yeah, no, I've been coming back since last Thursday. 2-week jury trial was supposed to go ahead. Every day we come back.
Okay.
Sorry, what?
Paint the picture. Paint the picture what it's like. You go to trial for a jury trial. You've got dates booked. You show up. There's 20 lawyers sitting in a courtroom.
Well, we were by
All-
Zoom,
Maybe
close
one.
enough.
Okay,
Yeah.
but we've been there.
Okay, yeah.
We've had like minimum 12, but up to 20-ish lawyers sitting in a courtroom with their fingers crossed, hoping they can actually get a judge.
It's a lottery.
Yeah, so just so everybody understands, we're booking usually about a year to 15 months out. We block off this time specifically and block off time ahead so that we make sure everything is well prepared. We get there, the client has invested in their defense,
Taking time off of work.
taken time off of work, and you sit there, and you sit there on Monday, and there's no
Sometimes
judge
they
available.
have witnesses who've had to fly in from out of town.
Absolutely.
Well, people don't. You don't get a trial date in Superior. You get a trial the week of.
Well,
In many cases.
supposed to get a trial date, but now, like, we have 2 trials coming up in the spring. They were adjourned from last year, so there is a chronic shortage of judges in the Toronto area and in other jurisdictions
Sometimes
as well.
clerks, staff.
There is, but right now in Toronto, there's at least 7.
We're down 7.
At least seven, if not more, that is needed in Toronto to get them going. And I had never seen it this bad. I mean, I know, this has been complained about over the last decade, but most of the time I was able to get going. In the last several years, it is almost impossible the first time you're up for trial in the Superior Court to get going.
So when you go in, you find out what your priority level is.
Yes.
Right?
Yes.
So they'll say, okay, well, this case has been in the system for too long, so we're going to prioritize this up at the top.
Yeah.
We were 2. We were number 2. And we still didn't get a judge.
Yeah.
Yeah, and again, it's because of chronic underfunding of the system, and
I
part
was
of that
number
is
3 today.
part of that is appointing judges. Yeah, you were number 3 and you
I was
didn't get
number
reached.
3, and the judge apologized. He said, "Look,"
It's not the judge's fault.
he said, "if I had the 7 judges, your trial would be starting tomorrow. We're down 7 judges. Talk to the government."
Yeah.
And the Chief Justice talks about this all the time and tries to get the resources. It's not there. It's like when we're trying to get your trial on at 10 Armory. They built this beautiful, I don't know,
IKEA
multi-story
style courthouse.
It's a little better than IKEA,
Well,
but
it's very yellow.
it's very yellow, but it's nice. It's a nice courthouse.
Oh,
I
that
don't-
sounds
I don't-
terrifying. Like
I don't
you're
love
going
the
to
mustard.
court, and
it
it'll
looks
be
like
like a
I get-
place you can never leave.
Right.
You
Well,
just
it's
go-
kinda
But
like
but
that.
your access to justice is an issue because now they've centralized the courts in Toronto. So it used to be, you were at
5 different
Metro
strip mall
North,
courthouses.
and Etobicoke and Scarborough. Now it's all centralized. So this is another issue in Toronto. So I don't know what other jurisdictions have, but we're a big enough metropolis that we should have satellite courts.
Right.
What
And they did away
happened?
with them.
We went to court another day, and we had to keep switching judges because they only had court staff. Because you need to have the court clerk and the court reporter and, the people that knock on the doors to get the judges in or whatever. They have to have,
The
of course,
door knockers?
the door knockers. They're a little more important than that.
Exactly.
But so they only had staff for one courtroom, so the judges had to keep switching.
Right.
We had 3 different judges.
And you know why that
rotating.
is? Because they centralized the courthouse, and the court clerks who were in other jurisdictions can't afford to come down to Toronto because they have to pay for their own parking or they have to pay for their own commuting, and it's more expensive to be down here. The commute is much longer, and they couldn't do it. And nobody bothered to speak to the court staff. It just happened, and that's why. And it's a chronic problem. And I don't understand in a city where we have 3 million or more that we don't have satellite courts. And
Well,
now
you
it's
would have
centralized.
thought if anything good could come from the pandemic, we managed to handle a lot of things a lot better over Zoom that they should continue doing.
Right.
But then now we're going back. There's a lot of things I think we could still do by Zoom.
Oh,
I just worry because the backlog is never going to go away, right?
Well, I just think that this is where governments talk tough on crime but don't invest in it. We're the defense lawyers. They need to be invested in it too. Legal aid is finally getting a boost. But we can have a system crumble if government doesn't invest in it. And I get that there's competing, healthcare and education, etc. But frankly, if you want a functional justice system, you've got to invest in it. So getting your trial on for a jury trial in Toronto, that's another one. Would you talk about disclosures being an issue? Because that went through a metamorphosis over the pandemic.
I think it's better now.
Yeah.
We're getting it electronically, although 2 different systems, but it's going to change apparently next year.
I hope
I
so.
miss the DVDs. I got to tell you, we used to get the hard copies on DVD and stuff, and And then when it's electronic and trying to make sure it's
The digital
copied
download. Well, at least
I'm
you
not the
can-
best with the digital download.
I know
I gotta
that.
say,
We're
you
old
helped me a
school
lot.
though. We like
yes.
to print everything on paper.
Well, we still do. I mean, look at our basement. We've got everything's a box. We print everything out. But
I
but
know.
getting it electronically is great. You don't have to physically go to court. You can download it.
share it with the client.
Share it
as
with the client.
where
There's-
you're allowed.
It's definitely better that way. But there's an overload to everybody now. There's an overload to Crown attorneys, an overload to courts, to clerks within the Crown Attorney's office, and us. Tons and tons and tons of emails just to get certain things done.
Oh God.
Right.
You have to go to this portal to book a pretrial, and you have to give your blood type and your blood pressure, and then the name of your first child, and then you can get in. Like, I spoke to a Crown attorney who was hilarious, saying, "Okay, in this jurisdiction, you have to give the following information. So I'm just going to email you the form. Please fill that out. Please, please, please do not copy me on your email to the trial coordinator. I don't want another email. Just book it whenever the hell you want, okay?" Yeah. So you got to be precise. And then I had a problem. I think my finger mistyped a date or something. And I like 3 days later, I get an email back, "This isn't right." So I have to do it all over again. Not like, okay, I know what you're talking about.
This is why you don't like MacBooks. All you have to do is put your fingertip on it.
Here we go.
I hate MacBooks. But the technology aspect now and what we've had has created a crushing amount of emails and communications, which is making it very difficult for Crown attorneys to be on top of their work. It's certainly, I come to my office and people know, don't walk into my office between 9 and 10 a.m. because I got to deal with like 1,000 emails.
I remember I put a sign on your door one day that said, "Before you knock, ask yourself, is this really important?"
Yeah. But you were really...
And is it worth dying for?
Is it worth dying for? Right. You literally have to go through these tons of emails. I'm tied to the phone.
Oh, God,
You
yeah.
got to go through it. And
crazy.
some of these workers, the other thing is the hybrid system.
Well,
So
it's not
there's-
just that, is that you have to make sure that everything's copied and placed into the right place so that it's all in the files and then it's also printed. And,
Yep.
there's so much stuff that people don't understand. So I think...
It's impossible because there's some who think you can go totally technology, right? Yeah. And you bring your laptop to court and you can do everything off of it. And I said, and we've hired recently, I said, if I see you doing a cross-examination off of your laptop, I'll break your laptop and I'll fire you. Okay? You're going to get a binder, you're going to put the notes in there, and you're going to do it properly, okay? Like old school, so that you can actually look at a witness and not look at your goddamn screen and sit there typing away at it,
Or your battery level.
So we are old school that way, but it's a lot of work. You got to download it, put it into the right folder, print the thing, put it away, and then I got to deal with the 10,000 emails to set up a pretrial.
I know.
Or a judicial pretrial.
But it's just like, I think all of
Are
this...
we boring all of you?
All of this is
We're
just...
boring everybody.
No, all of
Our
this is-
last end of the year episode
yeah, and we're
is
talking
just
about administration.
boring.
Yeah,
We're just
yeah.
talking about
No, but it's
administration.
important for people to, because a lot of people think, you just sit there with your feet up on your desk or
And win
whatever.
cases, yeah.
So, I think it's important for them to realize like how much
It's not a grunt work.
information management and, not just receiving the information, but breaking down information, organizing information, all of this stuff.
Communicating it to the client, ensuring we're in constant communication with them, answering their questions. It's a whole thing. I have a number 4, and we've talked about it before. I think there still is an absolute unequivocal disrespect for an accused in the system.
Yeah.
I
In
praised
terms
their system
of,
at the
is the
beginning.
system broken?
As far as the system is broken, I as my end of year podcast with my colleagues here, I still think something we can do better that we've spoken about in a previous episode and all the episodes is there needs to be more respect for accused in our system.
Mm-hmm.
I was so pleasantly surprised. I recently had a trial where the judge, when she walked in, this is Superior Court, she would say good morning to everyone,
Yes.
starting with the accused. Good morning,
I've
sir.
seen that a lot, actually.
Yeah.
I find that
impressed.
very respectful in a large part. But I think...
Not always.
I think your little gender-free statue, we need to make sure it starts out here. I just can't resist doing that
I
again.
know you
'cause it was,
can't. It's like,
but it does seem sometimes like it starts out like this, like the complainant's evidence is already given so much weight, of
course.
and the accused is fighting that uphill battle, and we need to make sure that it stays like this at the beginning.
Yeah, I mean, I don't mean it so much in hi, Mr. So-and-so or hi, Miss So-and-so. I mean it more in about how we go about adjudicating these cases. And I think sometimes, we just feel it's an uphill battle no matter what. And it would be nice if we just have a little bit more of an even playing field. I mean, somebody argued to me today in a case that well, the defense wants all of this. We have to level the playing field, and I can say all this shit about the accused. And I'm like, bring your discreditable conduct application. I'm not frightened of it. But that's not the point.
Right.
The point is my client was disadvantaged because it was thought by both the prosecution and the judge at the time that I'm not allowed to do and marshal this evidence. And it's like, no, you can't box somebody in. We need to really get the message out and really work in the system to try and level the playing field more. Mm-hmm. When somebody is declared an offender in a fair trial, beyond a reasonable doubt, where we feel that the conviction is solid, fine. That's when you shift to the penalty phase of a case and the person's an offender. And we still have to treat them
still with respect,
civilly, because that's the distinction between a civil society and a democracy that we want to be a part of.
And a gulag.
And a gulag, and a closed society. Yeah. That said, at the front end, we still need to do more to make sure that this is a level playing field and to make sure that the high threshold of proof beyond a reasonable doubt stays where it is. And at the end of the year, and you brought it up, that Saskatchewan case, I feel robbed of jury trials.
Mm-hmm.
Yeah, I know.
And to the end of my career, I will forever hate that decision. And I will forever hate the amendments that came in afterwards.
It wasn't the decision that was wrong, it was the reaction to it.
Well, I don't know whether the jury verdict was correct or not on the facts. We weren't there. Right. But I hate that was used as the crucible to over our system. So that now, I love jury trials. They're fun. Mm-hmm. And juries, in many cases, are great because they're your peers. But you have to select the right jury. It can't just be anybody, because a lot of people don't want to be there. Right. A lot of people do.
So these are things that we'd like to see addressed, and I think
that's broken, and it's never coming back.
We have to write a Canadian version.
One more thing. Don't cut me. What time are we at?
We have to write a Canadian version of the Lawn House.
One more.
Can I talk about my favorite moment this year when you're done, though?
Preliminary inquiries. You just found a case that went into our newsletter where a judge actually lamented about I hate the loss of preliminary. Yeah. Good for that judge.
Yeah.
See, it's getting exciting at the 40
Bill C-75.
Yeah. Got rid of preliminary inquiries for offenses 14 years or under. Right.
And if it had been granted, then they could have avoided trial delays that ultimately ended up in the charges being dismissed.
Because a preliminary inquiry, which Justin Trudeau and his then Minister of Justice wanted to get rid of so that victims of violence don't have to be re-traumatized by being in a prelim and then a trial, actually does a harm to everybody across the board. It's a disservice. Yeah. Because prelims are very important, and most good lawyers didn't use as some sort of bashing fest. No. We did it as a legitimate means to get at evidence, and many cases resolved after the prelim.
And you can find out if there's missing disclosure. There's all kinds of things you can
lay the groundwork for a third party's record application. It was incredibly important. And for the life of me, they left it in with cases of sexual interference where you deal with children who I can understand may be actually more traumatized than an adult when they come forward.
We make a lot of concessions with children, though.
We do, but they left that in and they took it away for everybody else. Right. So that I've got one more and then I'm done. And then you can say your point.
I'm just going to finish with a funny story.
CCTV testimony. Okay. CCTV testimony.
Here we go.
So a complainant in a sexual assault case gets to testify by Sony TV. Okay.
Or Samsung.
Samsung. They're both good.
Yeah, I know.
And frankly, the LG's great. I
think I've got LG. Yeah, it's not bad.
The new LG was pretty good.
74-inch?
It won't fit. But anyways, so that's where it's almost presumptively believed that if you're a complainant in a sexual assault case or domestic violence case, you can testify by CCTV. It's like, what do you mean you're opposed to the opposed?
So they get to sit in another room and then just testify via TV, almost like a Zoom hearing.
Right. Cross-examining somebody through a TV is not good, okay? If you were all on Zoom, fine. I don't have a problem. We're on an even playing field, and we didn't lose a lot by it. But when you're in a courtroom and it's a screen there, it's a problem. And you just won a decision in a case where the judge denied the complainant because she was just upset about having to testify in court.
Yeah, she broke down for a few minutes during an interview with the Crown or the cop.
So explain what the what the requirements are in order to grant one properly.
Well, there has to be trauma evidence
of something beyond mere discomfort. So it has to be that there was
you're afraid or you're going to be uncomfortable. That's not enough.
There has to be something.
Everyone's uncomfortable when they testify in court.
I'm uncomfortable
unless they're a
sometimes when I go to
professional
court.
criminal or something like that. Nobody's used to being there. They don't like.
You need something
You guys walk
real.
around like just like, hey, how's it going? Because you're used to being there all the time. It's your
Right.
workplace, right? But
No, but everybody else is, and our clients are.
Right.
But you need somebody who's particularly vulnerable, particularly frail, mental health issues, other disabilities. Could be somebody's age, and or trauma, which is established with expert evidence.
well, and if somebody is saying that they were like forcibly confined and tortured for a number of days or so, you can imagine that they don't want to be in the same room as the person.
Right. So a particular allegation may lead to a particular trauma, which then, based upon some evidence,
But you still need some evidence.
there has to be some evidence, and then it would be justified. But you can't just do it across the board, and that's one thing. And we're fighting them all.
Oh, yeah.
We're conceding them where it's appropriate. Okay, now be quiet, and you want to raise that one thing.
I just wanted to end the year with a funny moment from court that we were just like, what? We go into court for to find out the decision in our client's case.
Yeah, that was a good one.
We went into court. We're waiting to have our decision heard, and there were some other
The
matters
judgment
that
from the
came
trial.
up. The judgment from the trial. We don't even know what the judgment is. And then the court clerk says, "Are you
Right
here?"
in front of our client.
Right in front of our client says, "Are you here for sentencing?" And we're like,
I hope not.
"Do you know something I don't?" As it turns out, we got an acquittal. And it was a misspeaking, probably because they had a sentencing decision that came up before they actually spoke to us. But what a faux pas. Anyway,
Yeah, and my client was like, what?
I know.
Did I somehow get
We're
convicted?
all-
You didn't tell me?
We're all looking at each other. I know, but anyway,
that's funny.
thankfully, it turned out well for everybody.
So,
End of the year, end of the
great
glasses.
2023. Thank you, team. To all our viewers, to our producer, Max, thank you so much. And BJ, who's not here, he makes a guest appearance every so often. Thank you, Marcy, who keeps my hair in shape. Special thanks to all our viewers. Great emails. And I got to say this. Okay. I had the privilege of running into somebody who watches our podcast. I'm not going to name somebody, but I was in a city in Toronto. I was with my wife walking to go have lunch. It's out of town visiting an offspring at university, and somebody recognizes me, two offspring at university, and somebody recognizes me somehow and says, are you a lawyer? And I say, sadly, yes. And they go, do you have that podcast? And got out of the car, shook my hand, asked for a selfie. It was like adorable. And I was like, I was laughing because it's like, I don't think of us in any way like that, but it was just so wonderful. And it means that our podcast, we've done something here where people really like the information and it resonates with them. So so thank you very much to that viewer. It was an absolute pleasure and delight. You made my weekend. It was wonderful. But to all our viewers and to all the people who watch it when we go live, when we drop the podcast, and you have all the great commentary, you've been great supporters for our 99 episodes. So thank you very much, and we really appreciate it.
Don't forget to like, comment, subscribe, and share, and stay tuned because we will be back in January with episode 100.
Stay tuned for merchandising in
night,
2024.
Yeah,
The t-shirt.
the t-shirts.
Excellent.
Get some merch, baby.
Got to get some merch.